we turn to the second aspect of fundamental rights as a limit on union power, fundamental rights in the EU's Charter of Fundamental Rights. This is a development led by the governments of the member states as masters of the treaties. So in terms of the legitimacy debate, it's quite different from the court-led general principles approach. There was no mention of fundamental rights in the original treaties setting up the EEC. Now, Article 2 TEU provides that the Union is founded on the values of respect for, and then there's a list, which includes human dignity, freedom, democracy, and so on, human rights. So the Union, the basis of the Union, the foundation of the Union, includes respect for human rights according to its treaties. The Union is also obliged to contribute to the protection of human rights in its relations with the wider world, and that's found in Article 3.5 of the Treaty on the European Union, an obligation which should, at least in theory, inform the European Union's negotiations with so-called third states, i.e. countries that are not member states, such as the United Kingdom. The Union now has its own Charter of Fundamental Rights, which has the same legal value as the treaties, and the legal authority for that proposition is Article 6 TEU, which says the Union recognises the rights, freedoms and principles set out in the Charter of Fundamental Rights, which shall have the same legal value as the treaties. The Charter is divided into 6 substantive chapters on dignity, freedoms, equality, solidarity, citizens' rights and justice, and a 7th chapter has horizontal provisions which cover its scope of application, who is addressed by the Charter, how the Charter relates to other legal instruments, and the standard of protection offered. So again, I would like you to pause the lecture in a minute and find the text of the European Union's Charter of Fundamental Rights online. You should be able to find that pretty easily using Google. Make sure you use an official source like EURLEX, and make a note with the 6 headings of each chapter, and then list the rights that are found in each. When you're aware of a similar right in the European Convention on Human Rights, then make a note to that effect. So just pause here and do that. Article 51(1) provides that the Charter applies to the Union institutions. Article 51 of the Charter. This is the provision that subjects the Union legislature and its administration to human rights control under the Charter when the Union takes binding legal acts, either legislation or administrative acts. Acts that do not comply with the Charter are judicially reviewable under Article 263 TFEU or Article 267 TFEU. This is the basis on which, for example, the Court of Justice of the European Union has found that Union legislation requiring member states to freeze assets of entities and individuals found by the UN Sanctions Committee to be connected with Osama bin Laden or the Taliban, under circumstances where there was no opportunity for such individuals to challenge their inclusion on such a list through judicial process, was unlawful. See the Cadi litigation. So now we turn to the second main point of the lecture, fundamental rights as a limit on member state power. And again, we need to start with Article 51, subparagraph 1 of the EU's Charter on Fundamental Rights, which states that the Charter also applies to the member states only when they are implementing union law. This very clear-sounding legal rule is, perhaps unfortunately for us, not as simple as it sounds, not least because there is previous case law of the Court of Justice of the European Union about when human rights as general principles of EU law apply to limit member states' actions. And this case law has not been completely replaced by the EU Charter, at least not in the way that the Court of Justice has subsequently interpreted Article 51(1) of the Charter. The previous case law was in terms of both member states implementing EU law, but also in terms of member states acting within the scope of EU law. So turning first to the question of implementing EU law, to understand this, it may help to remember that the EU is actually a very small organisation in terms of the number of staff it directly employs, smaller than a large English county council. Most of EU law and policy takes effect because it is actually implemented by national administrations. So it makes sense, therefore, for human rights control that applies to the Union to apply also to those implementing acts. It may also help, and here you may need to come back to these notes once you've covered the second module topic on the internal market, to remember that where EU law creates the internal market, that is an area of shared competence between the EU and its member states. So some market regulation is EU law and some is national law. When a member state wants to adopt market regulation that would impede the freedom of movement of factors of production, products, services, people, companies, capital, it has to show that its domestic legislation is justified and necessary. One possible justification is the protection of fundamental human rights. The question of what counts as implementing union law has arisen in case law. A key case here is the NS case, involving the UK's implementation of the Dublin II regulation, which concerns which member state is responsible for examining asylum claims. This case obviously happened while the UK was still a member state of the EU. One of the first issues that had to be resolved in that case was whether the Charter applied at all. Poland and Czechia have negotiated what was called an opt-out, which also used to apply to the UK, from aspects of the application of the Charter in those states. But the Court of Justice held that the UK was obliged to comply with Charter provisions. On the substance, the regulation provided that member states retained the discretion to examine asylum claims, even when they were not the responsible state under the regulation. The applicants in the NS case were present in the UK and were challenging their deportation to Greece, the country responsible being their first port of entry into the EU. One of the grounds of challenge was a breach of their right not to be subjected to inhuman or degrading treatment under Article 4 of the EU's Charter of Fundamental Rights and Article 3 of the European Convention on Human Rights, given the conditions for dealing with asylum claims in Greece. Should a discretion on the part of the UK constitute implementing EU law for the purposes of human rights review? The Court of Justice held that it did. The UK must have been aware of the conditions in Greece, and therefore the member state was obliged to respect EU fundamental rights when acting under the regulation. Thinking now about acting within the scope of union law, the Court of Justice of the EU held that Article 51(1) EU CFR did not mark a break from its earlier case law in the Franzen case. The court held that fundamental rights control applies to all situations governed by European Union law, see paragraph 19 of Franzen. This was the case here, even though the Swedish tax legislation at issue had not been adopted specifically to implement a directive, but was designed in part to implement EU law obligations to collect value-added tax. You will note the imprecision of the court's phrase here, in all situations governed by European Union law. There is subsequent case law on the point, but as Craig and de Burke note on page 464, that subsequent case law is still at a level of considerable generality and abstraction. This is still very much an area of union law that is open and being developed through litigation. The overall point, though, stands. If the matter falls within the scope of union law, or can be brought within it, then European Union human rights, as set out in the EU Charter and as general principles of union law, must be protected. This is illustrated by the Carpenter case, which is on page 250 of Barnard and Peers. It's one of their case studies involving the right to family life. Here the applicant argued that his wife's deportation was an unjustified breach of his ability to provide services in the internal market because it breached the right to family life.